In 2021, he teaches courses and researches in constitutional law, evidence, international criminal law, and military law. Before becoming a full-time law professor, Professor Rosenblatt first chaired litigation in federal and state courts at Butler Snow in Ridgeland, Mississippi. Before that, he served in the U.S. Army, JAG Corps as a prosecutor, legal advisor, and defense counsel, including as lead military defense counsel for Sergeant Bo Bergdahl in the most publicized court-martial in American history. A recognized expert in military justice, Professor Rosenblatt serves as the president of the National Institute of Military Justice, an organization devoted to the fair administration of justice in military tribunals. He is also an appointed special master for terrorism cases for the U.S. District Court for the District of Columbia and a Court of Appeals judge for the Mississippi Army National Guard. Professor Rosenblatt has been invited to speak to several of the world's flagship institutions, including the Peace Palace in The Hague, the Pentagon, Yale Law School, the Hoover Institution, the French Senate, the Indian Progressive Lawyers Forum, and Edinburgh University in Scotland. He has authored numerous articles, book chapters, and co-written 3 books. His work has appeared in numerous journals. He has filed amicus briefs at courts including the United States Supreme Court and the International Criminal Court in The Hague, where he presented oral argument in 2022. He recently co-founded a new international law journal, Forces Law Review. Professor Rosenblatt continues to represent clients in national security cases and maintains a robust pro bono practice representing Mississippi juveniles who have been sentenced to life without parole. And most importantly, I think, Dr. Rosenblatt, you are proud of, is that Professor Rosenblatt has been selected by students for numerous awards, including Best Mute Court Coach in 22, Best Pro Bono Contributions in 22, 24, and 25, BLSA Professor of the Year in 2024, Order of Barristers Honorary Member in 2025, and Professor of the Year in 2023, 2024, and 2025. He was also selected by the faculty at the law school's nominee for University Professor of the Year in this year, 2025. Let's give a warm welcome to Dr. Franklin D. Rosenblatt.
We're all among friends, so call me Frank. We're here to talk about my favorite class to teach, and that is First Amendment. This is the First Amendment of the United States Constitution from 1791. The Constitution was finally ratified in 1789. But in order to get along those more skittish colonies, they needed some sort of guarantees of individual rights. The rights that are listed here are very much reflective of the experience of those who ran away from England and other countries in distaste. For example, if they weren't members of the Church of England, they would be subjected to heresy, harassment, and prosecution for their heretical religious beliefs. So they wanted religious freedom. They wanted some hardcore protections for speech because the printing press in England would face government pre-approval before they could list stories. People couldn't, if you said bad things about the king, you would be held liable. And so people said, we want none of this. We want no kings in the United States of America, right? We want speech. This is the core, I think, American right. There are many democracies with strong protections of free speech, none as strong as what the First Amendment, as interpreted by the Supreme Court, says in the United States. So there are 6 basic rights here, and we just have a limited amount of time. So I just want to talk about some of the ones that I think are most fun or most interesting for us, and then I really invite your interventions. I want to hear, what does the First Amendment mean to us, and where are the areas where we can better, inform our networks about what it is. This is all empowering. It's becoming the right of rights. Now, what's listed here, it seems pretty absolute. Congress shall make no law. In reality, I took the First Amendment and ground it up into how it's actually been interpreted by the courts. What this means is there's a requirement for state action, right? You know, when I tell my kids they have to go to church or they can't make fun of my cooking, then that's not a violation of their First Amendment, right? Because this only applies to state actors. We are really just concerned about when government at any level, federal, state, or local, so that means our public libraries, our schools, our police, our elected officials, government at any level is where we enjoy protections from. And there, rather than the make no law, we've really brooked a number of exceptions, limitations, and balancing tests. There are, of course, many reasons why the government could restrict speech. If I make a violent threat against you, then there should be a consequence to that. Or if I advertise the breakfast cereal I'm selling and I say, this is going to cure cancer, right? That's false, right? And so I can't do that. So I don't have the free speech right to make up false statements all the time. But that said...
Don't mind me, I'm going to do your slides.
Oh, good, thank you. So, and we'll go to page down for the next one. I want you to see what's actually covered by religion as well. And here on religion, we have two basic protections. One is the Establishment Clause, and that means the government at no level shall tell us what is orthodox in religion. We can't have a local government say, we're a Christian state and we're going to go after those who do not believe in what we do. And the other side of that is the individual right of free exercise of religion, that we all get to practice our own individual faiths. And so there's a lot where the government needs to stay out of our business. You can say, for example, some people have been saying, I don't want to take the COVID vaccine because it's against my religious beliefs. The government can't say, well, let me interrogate you on that to see if you really know what you're talking about. Is that the correct interpretation of Leviticus? We just say, government, stay out of this. When people claim religion, most of the time, they get some protections for what they can do. Next slide, please.
Wait a minute. I want you to go back and explain the last two lines. The free exercise clause prohibits government from abridging religion unless it can satisfy the demands of strict scrutiny.
Yes. So strict scrutiny here, I've given the judicial language. When courts face these challenges, this largely says strict scrutiny is the highest level of scrutiny for a court. And that means that the government needs a really, really good reason. It means that the government has the burden of proving that whatever restriction they have imposed is necessary to achieve a compelling state purpose. Here's one example. If they say, soldiers, you're about to go off to war and we need to give you a vaccine, and they say, I have an objection to this, the government would have the chance to prove the only way we can achieve our objective is through doing this. And the court's going to take a really hard look. So strict scrutiny is very protective of individual rights, but it doesn't mean that the government can't overcome it. It just it gives the formula to courts that it's a very high standard. Okay. And down to 2. So what this means is we're overall very protective of speech. That means we're a very noisy country, right? Generally, the default that the United States Supreme Court has given us is that more speech is better, right? We really apply that strict scrutiny standard when the government is limiting speech. So for example, I don't like getting robocalls and these spam text messages and things, but the evaluation of that is, it's speech, right? Even though it's not sincere speech, it's not socially useful speech, it's annoying speech, but it's not a crime. So there's a lot of things that we don't like, ideas that are horrific and offensive and terrible, but for the most part, people get to express themselves. So this is not only speech and expressing their views, but also what we call expressive conduct, right? Now, I learned in Boy Scouts that the proper way to dispose of an American flag that has reached the end of its life is to respectfully fold it up and put it in a fire. But other people burn the American flag, and what's going on here? We don't like when they do this. Why don't we like it? Because they're trying to send some sort of message. It may be an inarticulate message when you burn a flag, right? But it's some sort of message you're expressing that I'm not happy with this and I want to burn the flag to show my distaste. So in one of his opinions, Justice Scalia said, this is protected speech, right? So the government can't come along and say, you're going to jail for burning the American flag, but if you want to burn a Palestinian flag, that's okay, right? Because that's the government engaged in content-based restriction on speech. Content-based restrictions enjoy that standard of, do you remember it? Strict scrutiny, right? So when the government says, you can't talk about certain subjects, very high standard. All right, government, you need a really good reason for that. For example, say I'm running a school and I say, okay, this Israel-Palestine stuff is getting really contentious. No one can say the words, from the river to the sea, Palestine will be free, right? Why is that? Because I, as a government official, am engaging in viewpoint discrimination, and that is a content-based limitation on speech. Okay, but now I'm smart on First Amendment. What if I say, fine, I get it now. Nobody can say anything at all about Israel or Palestine. Am I off the hook now? No, I'm still engaging in content-based restriction on speech. I'm saying you can talk about whatever you want except that acrimonious foreign affairs issue. So I'm still engaging in content-based restriction on speech. Now, sometimes the government can get around content-based restrictions on speech. Oh, one way, for example, is the government gets to share their own views. For example, if a social media company gets a letter from the president that says, we are concerned that these foreign bots have built accounts and they're trying to undermine the election. Is that a content-based restriction on speech? Depending on the facts, the answer might be no. It's simply that the government is sharing their own views about what this social media company is doing. On the other hand, if the social media company responds and said, well, we just felt like we had to shut all that stuff down because we felt like the government was putting pressure on us, then they're developing the argument a little more that it's a content-based restriction on speech. Another time when it's okay for the government to engage in content-based choices on speech are when the government is in charge of making those. And I can't think of a better example of that than libraries. Do we have a right to have libraries put whatever book exists in there? If I write a book that sells 3 copies, does the government violate my free speech when they decide not to carry it? No. The government, through our librarians, who are representative of our communities, make content-based choices all the time in what's going to be best for their people. And what we saw in there, we were talking, this was hard to watch, the preview to the librarians, right? How that's being undermined by outside groups and saying, no, you don't have the right in your library to have a book by Ta-Nehisi Coates, and we are going to intimidate and put pressure on you until we do. So that's its own problems. But librarians can make content-based choices because you have to. You couldn't have a library if librarians couldn't make choices on books. Next slide, please. Now, for most of our country, First Amendment wasn't a thing. That's hard to imagine, because in the last 20 years, the First Amendment has become the right of rights. If you can identify a First Amendment angle to whatever argument you want to make, then you're likely to have the law behind you. It really has become more important and more prominent in cases featured before the United States Supreme Court than ever before. But this wasn't the case. This is Reynolds, for example. I was out in Utah, a member of the LDS, as you can probably guess. He says, my religion calls on me to be able to have multiple wives. And the United States Supreme Court said, well, that's interesting. Let's dust this off. Yes, we do have this First Amendment, but we basically interpret this to mean that the government needs to be neutral towards you. And so if the government is treating everyone the same, we think it's fine that Utah says that polygamy shall be banned. We can't have people, if everyone could exercise their religion however they wanted, this would lead to like Dutch Presbyterians in New York City following their burial requirements to put members of their congregation right out in front of the church, which happens to be some of the busiest cities in New York. So if we're treating religion neutrally, we're okay. But the speech rights that we had weren't what they once were. In Schenck and other cases, it was another time where we were very much, the public imagination was captured by our participation in World War I. And the thought was this: a lot of people were getting in trouble, and the courts were upholding that, saying, you posed a clear and present danger. What were they doing? They were making a speech like, I don't think we should go to this European war. I think our sons have better use of their time, and I think this war is a waste of time. How could the courts possibly say that was fine? In the old text, the way we used to do things, they said, well, if that gets printed in the newspaper, then our boys out on the front lines may get a copy of the New York Times, and they may read this. And if they see the dissent that's going on at home, it's going to lower their morale. If their morale is lowered, they're less likely to fight well. Therefore, limiting this speech, it poses a clear and present danger to our ability to win the war and have national security for America. Ridiculous, right? So that standard went away, and I think we became more speech protective in the 20th century. A lot more. In fact, in the next one, on Brandenburg, we see how protective it is. Clear and present danger test is tossed out. Go ahead. This was it's a good example of this Ku Klux Klan. Like, they're notorious, they're obnoxious, I don't like what they do, but everybody, even unpopular groups, gets their speech. Here's what's happening at a KKK rally in Ohio. One of these guys stands up and he starts spouting all this racist stuff, and then he also says, and I think we should have violence. Let's take to the streets and let's do something about this. Under the older standard of Schenck, they would have said, no, clear and present danger, that's a problem. But in Brandenburg, we gave the most, and this is still the standard today, the most speech protective rationale that's possibly out there. That speech is protected, even though it's racist, even though it's violent, because it wasn't sort of an imminent call for violence. Only when imminent harm or likely imminent illegality, only then can the speech be limited. Otherwise, bad and obnoxious views are protected. And next one, please. So, and sometimes the government tries to do things that are designed to overall chill expression. And this is a case from London that showed what we wanted to get against. She was a ne'er-do-well, Miss Manley, and she liked to go around and give false alarms to the police. There's an emergency over here, and then she would laugh when the police would respond, and nothing had actually happened. And they penalized her under a statute that says, no annoying conduct. How would that go over here? No annoying conduct. So she's convicted of annoying conduct, right? Is that a good result? What's wrong with that? Who decides if what we're doing is annoying, right? And we want that, let's say we're videoing the cops and they're pulling someone over. We have a suspicion that somebody's rights might be violated. Is it up to the cops to decide if we're being annoying? No, that's too vague. It's overbroad. Overbreadth, Jews for Jesus, they challenged a law in the Los Angeles International Airport that said no First Amendment activities in the airport. What does that mean? Does that mean you can't wear expressions of your religious faith? Or you can't wear a shirt that says, I don't like Trump or something like that? It's so overbroad that the thought is that when the government is big and overbroad, it's going to chill a lot more expression than otherwise. Because everyone's like, I have no idea what I can do that's going to get in trouble. And some of the military cases I'm working on now, in the Kirk purge, after Charlie Kirk's death, the military is cracking down on anybody, any soldiers, who are expressing any views on social media. And so that's causing the classic vagueness and overbreadth. Everyone's saying, I'm not going to say a thing because they're going after everyone for any reason at all. No one can tell what the standards are. And that's exactly the point. And slide. That's vagueness and overbreadth. And now, can I tell you, all right, First Amendment's my favorite topic, and can I tell you about my favorite case?
Yes.
It's called New York Times versus Sullivan. Has anyone heard of it? Okay, the next slide, please. New York Times versus Sullivan. This is about, sometimes defamation, libel, when that's not protected. You don't have the right to, say, I can't make up false claims about you and tell all your friends. There's got to be some liability for that. That's defamation if I knowingly say false stuff about you, right? But many countries around the world have called lèse majesté. It means, like in the king of Thailand, if you're in Thailand and you say something about the king, negative, you're going to go to jail, right? And so back to our traditions, if you said anything that was libelous, anything that caused the reputation of powerful, rich people, including the king, you're likely to be beheaded or face criminal consequences. How does that work in the United States of America, land of the free? Slide, please. We saw this in 1964. We recognized Dr. Martin Luther King in Montgomery. A group called Heed Their Rising Voices was responding to Dr. King was beleaguered. The entire state of Alabama, at least the government system of Alabama, was out to get him. Most recently, they put him up on charges for perjury. So Heed Their Rising Voices is a group of a lot of civil society activists, and they put out a full-page ad in the New York Times. This is people like Jackie Robinson, Marlon Brando, Eleanor Roosevelt, and they're trying to call to the public's attention what is going on down in Montgomery, Alabama. Now, as a lawyer, we're all told that it's the courts and the civil rights cases that made a difference down there. But I think more realistically, we've got to say that the civil rights revolution that happened in the 1960s never would have happened if the country was not informed of the horrors of what was going on in Mississippi, Alabama, and Georgia, how people were actually being treated, how they were being attacked by dogs, beaten, pulled from counters. If the country was never able to see that, the momentum wouldn't have built to actually implement the civil rights, end Jim Crow, and end desegregation. But how does that happen? You need cameras down there. You need reporters. You need people who are reporting the facts and conveying them to a wider audience. But in the South, in the 1960s, it was a very hostile place to reporters from the New York Times and other journalists. They stayed out of the state. But still, they were able to tell their stories through things like this. But here's the twist. In Heed Their Rising Voices, they talked about how a group of students in Montgomery was brutalized and silenced for speaking out for Dr. Martin Luther King. This ad contained a number of statements. And just like any news story, you may not get everything entirely correct. And here's what happened. They said that Dr. King had been arrested 7 times. It was actually 4. They said that a student group had been surrounded by police. In actuality, it was just a bus full of police that came up with guns and tear gas canisters. So a number of other smaller things like this, and it didn't actually mention the police commissioner of Montgomery, Alabama, but Mr. Sullivan, the police commissioner, said, they can only be talking about me. And if people in the community read about this, this is going to hurt my reputation as an elected public official. So he sues the New York Times, right? Now, if this goes off to federal court, it's going to receive more of a neutral review. But he was a little clever. He doesn't just sue the New York Times. He also sues 4 of the signatories who were local in Montgomery, Alabama. And what that meant was that the jurisdiction of the court shifted to the local Montgomery court system, right? Do you think the New York Times stands a chance in the Montgomery court of Jim Crow 1960 Montgomery, Alabama? Absolutely not. So the judge applies the following standard. He says, jury, you have one question. Did the New York Times print this? And if you find so, then they're guilty. That's it. So the standard was that news publishers, if they couldn't prove the truth of what they did, they were automatically guilty. And so they got a $500,000 assessment, as did these local Montgomery preachers. They had to sell their houses to try to pay off. This became the way that the South and Jim Crow fought back. They kept bringing these libel and defamation lawsuits in local courts, racking up these $500,000 figures. Soon, the Times and others owed $300 million to Montgomery plaintiffs who were supposedly defamed. So in the landmark case of New York Times versus Sullivan, the Supreme Court was asked the question. On the one hand, we accept that states can have, defamation laws. But on the other hand, we have protections for a free press in the First Amendment that are so necessary. And if defamation laws are exploited to take advantage of that, then the effect is to crush the free press. Nobody is going to report on Jim Crow and desegregation if they keep winning at defamation. So they changed the standard. They changed it to actual malice. It shifted the burden. Rather than critics having to prove the truth of their stories, it changed around so now that the powerful had to prove the falsity of the stories. With that big burden shift, the New York Times prevailed. This was a landmark, big protection for not only the free press, but also for free speech. Next slide. So we can see how this plays out. For example, in the Fox News after January 6th, they start losing viewers because they start, telling the truth about what had actually happened. And the more radicalized viewers, they're going over to One American News and others. So Fox says, look, we need to double down on this story that these election machines were rigged. So Dominion is one of those. And they keep raising this thing like Dominion was bought off by Venezuela. They tossed out hundreds of thousands of votes for Trump. But they knew that it was false, right? That's the difference. They met the standard of actual malice. So Dominion sues them, and this time actual malice is met. Unlike in the New York Times, they meant to tell a good story, right? They were trying their best to tell the truth. But when you've got actual malice, this leads to astonishing settlements now with the First Amendment. The slide, please. We see one of these, for example. Sidney Powell, the famous election denier, kept going on Fox, and Tucker Carlson, right? He no lefty, but Tucker Carlson says, you keep saying that Dominion rigged these elections. When are you going to offer the truth of this? So there are all these emails and things that show that Fox knew exactly what they were doing. They knew these claims were bogus about Dominion, but they kept running them anyway. So they could meet the standard of New York Times versus Sullivan. They proved actual malice. Slide, please. The free press is not that free everywhere. For example, Mississippi today, I don't think we could say that Mississippi is like the most welcoming place for journalists and for telling the truth and getting stories out to the public. Mississippi today is one of those. And the publisher gave a speech and did what we do all around the country. People are going to draw editorial cartoons mocking President Trump. They're going to make fun of powerful and elected officials. And so a Mississippi Today person gives a speech and says, it looks like Governor Bryant was pretty crooked. He played some sort of role in the welfare scandal that funneled money for poor people off to friends of Governor Bryant. So he sues them and says, you've hurt my reputation. And now, New York Times versus Sullivan, it's still a thing, but Mississippi courts don't respond right away. It goes to discovery. Governor Bryant tries to get into the text messages of all the journalists at Mississippi Today to see what they know, and is largely designed to intimidate and crush and pressure the press. So, next slide, please. And that's why 34 out of 50 states in the country have done something to give some more meaning to the New York Times versus Sullivan standard. They passed what are called anti-SLAPP laws. That says that when powerful people go after the little guy, they try to censor, intimidate, and silence critics by burdening them with the cost of legal defense. It basically says that presumptively the First Amendment is there. It calls for these lawsuits to be tossed out, for the powerful people to generally pay the costs of the challenge unless they can prove that they're truly meritorious. Without anti-SLAPP, you stand every chance of if you go to Red Lobster and you don't like your food and you give it a 1-star rating, what's to stop Red Lobster from suing you, saying you hurt our reputation? Okay? So we are not an anti-SLAPP state, which means we make it easier in Mississippi for the powerful to crush dissent by bringing lawsuits designed to censor, intimidate, and harass. Another one of those anti-SLAPP states is Virginia. And that's why you see Johnny Depp saying that Amber Heard, by raising these allegations of domestic abuse against me, you got me cut out from some lucrative Pirates of the Caribbean opportunities. And he brings a massive lawsuit against her and prevails before a Virginia jury. Next one, please. And once again, the powerful crushing dissent. Gawker was a irreverent news site and but when a tech billionaire goes after it, he was able to completely crush it. When Gawker had published an expose that Peter Thiel was actually gay, it's not really maybe the most professional and newsworthy story, but he said, you know what, I'm going to crush you guys. So he bankrupted Hulk Hogan in his challenge, and now Gawker is out of existence because the tech billionaire was able to take him on. That's why New York Times versus Sullivan is important, and this is why anti-SLAPP laws are important. Slide, please. And so briefly, we're just about done, but I want to say a couple words about religion, just so we can see this, because religion is becoming the right of rights. Once again, we have the Reynolds case, but let's just look at the demographics of our country and how religion is changing, because that's important for understanding what's really happening. For the next one, please, and then we'll come back to this. All right. So this is America 3 years ago. We're a more pluralistic, religiously diverse country than we were at the time of the founding, or really any other time. But as you can expect, we're not like fully diverse. There's not the same number of Baptists and Hindus in the country. We are still predominantly, they divide these up, white evangelical Catholic and white mainline Catholic. And Christianity is the dominant religion in this country. No doubt about it. Next one, please. But things are changing a little bit. On up to 2022, in the 15 years before then, the number of religiously unaffiliated Americans who have identified as that has doubled since 2006 to 2022. Anecdotally, there are some reports that may be changing, especially they say like with the Charlie Kirk stuff, a lot more young white conservative men are going to church than ever before. But generally, this number keeps skyrocketing, the religiously unaffiliated. And what's plummeting is white evangelical Protestant, white mainline Protestant. Next slide, please. So this is, and you see this is not only by Republican and Democrat, but also by age, that the religiously unaffiliated and others. And there's no such religion. I think it's like Black Protestant, Hispanic Catholic. But for the purpose of the polling, this is how they divided that up to see how that goes. But I mention this for one reason. The United States Supreme Court, as you know, there are 6 Catholics on the court. The Supreme Court now is predominantly a very conservative court, and it has grown to, I think it is viewing itself as reacting to these trends. Before 2006, there was no sort of need to say that Christianity has to be protected. Well, of course, Christianity is the dominant religion in this country. It doesn't need protection. But I think what's going on in some books I've read about, like Justice Alito and others, they are treating Christianity sort of like a cornered animal. Back when Christianity could roam free and had no challengers at all, then it had no reason to strike back. But now, with the rise of the religiously unaffiliated, the decline of evangelicals and Baptists, it's largely viewing itself as a victim, in need of special religious protection that wasn't needed before. So on up to those pictures, please. The slides before. Yeah, go back. Thanks. So here's how this happened. Yeah, this is perfect. The First Amendment's religion clauses, and then we will welcome your thoughts right after this. This is a guy who's smoking peyote in Oregon, and that smoking peyote is against the law in Oregon. It's a Schedule I controlled substance in the federal government, but it is also an important part of his religious experience. So he's smoking this. He gets fired from his job in Oregon. And he goes to collect his employment benefits, and they say no. So we've got a case called Employment Division versus Smith that just like this, he says, I want to exercise my religious belief without government interference. And Justice Scalia wrote an opinion that proved to be unpopular with both liberals and conservatives. It's called Employment Division versus Smith, and he's like, no, you lose. We reaffirm the holding from Reynolds. As long as the government is acting neutral toward the religion, that's all that is asked. Religion gets no special accommodation in American life. That's all the First Amendment requires. Right? Conservatives don't like that because they wanted the courts to be a little more energetic at protecting Christianity. But there's another interesting case. It was very obscure at the time, but is now taken on widespread significance in being used to protect Christianity. And that is Hialeah County, Florida versus Church of Babalu. These are practitioners of the Santeria religion. They are mainly Afro-Cuban descendants, and they have a different religious beliefs. Hialeah County is a predominantly white and conservative community. You can see the clash that's forming here. Right? So members of the Santeria religion, part of the exercise of their faith calls for animal sacrifice. They kill chickens and goats, and they have ceremonies for this. How do you think the city of Hialeah responds to that? In 1993, Hialeah said, we're tired of these immigrants. They don't fit in our communities, and they do these strange customs that we don't understand. We're going to pass a new law. The new law is this. The only people who are allowed to sacrifice animals can be butchers, and only for like traditional butchered meat. Right? What's the purpose of them passing that law? Yeah, to squash religion. They want to discriminate against the Santeria. So in a case that didn't get much attention back in 1993, the United States Supreme Court says, all right, religions win. We keep the rule that laws should be neutral. But when the purpose of government regulation is to squash religion, then strict scrutiny. Yeah. So when the government goes after religion, that's the view. Here's how this comes in very interesting ways. It would make sense. We could think of like these most marginalized religious communities may need that protection from mainstream who don't understand. We're looking out for the little guy in this. What happens is our religious conservatives on the Supreme Court, they're stuck with this ruling here, but they say, now we are viewing government actions as based on animus against Christianity. And therefore, we're using this precedent to say that those actions must be struck down. For example, in Fulton versus Health Services in Philadelphia, a Catholic social services agency is in charge of placing foster children into homes. This Catholic organization says, we will not place persons in families of same-sex couples, right? But Philadelphia had a neutral law. It said that same-sex couples are entitled to anti-discrimination protections. So what happens? The Catholics lose $26 million in grants because they were not in compliance with this. They bring a lawsuit, and the way this normally would have been settled is, all right, Catholics, you lose, because this was a neutral law. Philadelphia just gave it applies to everyone, anti-discrimination. But the conservative Supreme Court says, probably the only reason we have this is because Philadelphia hates Catholics. Therefore, the anti-discrimination law is struck down because, based on Lukumi, we find that this was a measure motivated by animus against religion. Likewise, Masterpiece Cake Shop, Colorado. Heard of that one? Yeah. Masterpiece Cake. What's going on here? Also, Colorado and the city of Denver have anti-discrimination statutes. But when a cake maker says, I'm not going to make any cake for those same-sex couples, right? What happens to them? Denver says, tough luck. We don't care what your religion is. We have this anti-discrimination law. Once again, the anti-gay cake maker takes the case up, and the Supreme Court was very sympathetic to their views that this was actually based on animus against Christianity. Finally, we see this in the COVID cases. As you know, in New York, San Francisco, Los Angeles, and it had a lot more closures than we did. And so when they said no one can go to any sort of large gathering because it's likely to spread the COVID virus, that was a neutral law. But some municipalities, they said, we will allow liquor stores to stay open, barbershops, and certain places where people just go in for a short period of time. But otherwise, these large gatherings have to stop. The Supreme Court says, oh, we see what's going on here. You don't like Christians. You're saying churches have to close, but liquor stores can stay open? We've exposed you. The reason you have these closure restrictions is because you hate Christians. And so they struck down these pandemic laws. That's religion in a nutshell. So finally, we see the power of religion arguments with this football coach out in the suburbs near Seattle, Coach Kennedy. He likes to take a knee at the 50-yard line, and he says he's just praying by himself. But all the players on the football team knew that if they didn't go over and pray with him, what's going to happen? Not going to get that letter for a D1 school, maybe move over to the practice squad. So they felt there was pressure to join him, right? He first brings his case and says he was fired for that because they told him, stop doing that. You're putting pressure on the students. And he says, I'm suing you. You violated my free speech rights, my ability to express my views. The Supreme Court hears up this case, and they have to grant certiorari to hear a case. That means 4 votes on the Supreme Court to do so. And they don't get cert on the Supreme Court case, but there's a cryptic note from Justice Thomas, and it says, if this case were to continue to develop the factual record with more facts to show that this might be discrimination based on his exercise of religion, we will be more likely to hear the case. Foot stomp on the ground, message sent. They develop this and they say, aha, it's actually the school district hates religion and hates Christianity. That case goes up. Coach Kennedy prevails. So his win at the Supreme Court, because they discriminated against him based on his religion, meant that he was allowed to get his job back. But when they called him up to offer his job, he said, no thanks, I'm making too much money as a Fox News contributor now. I don't need to coach a football team anymore. So that's how that story ends. So First Amendment in a nutshell, there's so many interesting things to talk about. I would love to hear what the First Amendment means to you, the challenges that you are seeing, or anything else that we want to talk about, because I think we have time for some questions now, right?
You want to just leave it here?
Sure. Yeah.
Questions? Comments?
Does Lawrence Oates have a case? The Ole Miss assistant that was fired?
Oh, wow. Well, the intimidation that's going on up against her is extraordinary. People can express their views, and from what I saw on this, and you may know more about this, but it seemed like this is her expression of her political beliefs. And so this would be taken up, I think, in a federal court up in the north. And I think the school, in their defense of this action, is going to claim some sort of vague standards to say, that employment here is discretionary, and if you're not a fit with our values, then how do you think it's going to play out?
I don't know. Does that hold up when they say it's social media policy or something like that?
It's interesting because when employers can fire people for bringing disrepute or unwanted attention on what they're doing, and I think that's definitely what they're doing. They can put forth some argument like people are going to stop donating to us if we keep her on the staff. Everyone's paying attention here. But she has a First Amendment claim. She is allowed to express herself. But there are consequences to our speech too.
What's your projection for the Supreme Court returning to a rational, reasonable stance?
I believe in the Supreme Court, and I think they need to be saved from themselves. From the idea. They need to be saved from themselves. And I think there are a number of things that could be done to rein in the Supreme Court. One is their jurisdiction should be more limited. Congress has the ability to constrain them. Right now, the Supreme Court is enacted to amass their own power and to pick and choose the winners as they want. And their key vehicle for doing this has been their method of interpreting the Constitution called originalism. Originalism is not part of our country's history, but it says that the only way to decide that government regulations are legitimate is to see if they were actually the same sort of things that would have been allowed at the founding of the country. Otherwise, it's just judges making up new laws. And we're just humble judges, and we're just bound by that. But originalism wasn't a thing before 1980. What happened in 1980? Phyllis Schlafly joins on the Republican train and says, we are going to take on Roe versus Wade. And before, the conservative movement had been based on stare decisis. It said judges need to be modest and restrained and respect precedent that comes before us. But you don't want stare decisis if your main goal comes to taking down Roe versus Wade. You need a different method of interpretation. They latched onto originalism. Originalism proved very useful in expanding gun rights and in gutting Roe versus Wade. And originalism is taking us in a lot of directions that are very undesirable.
What that assumes is that there's no precedent based on the cases that have happened over the century then, right? If you go back to the original interpretation, what they meant at the time, then there's no respect for the cases since. Is that?
You know, that's exactly how I talk about it with my class. And I think the worst offender with this has been Justice Thomas. He's saying anybody, a judge in 1940 who decided a case but doesn't share my views of interpreting the Constitution, well, then they're wrong. I'm going to overturn that. And he's announced his intention, like the cases during the Warren Court in the 1960s that gave us rights. He says, I want to get rid of Griswold, which gave us the constitutional right to contraception. I want to get rid of Obergefell and gay marriage. Lawrence, the right to same-sex intimacy. The one he didn't list was getting rid of loving, but that would be by the same rationale, right? What happens if, why does he leave loving off? Because it's his own marriage, right? Yeah. But loving rests on the same rationale as Obergefell, right? I think he just wants to tear it all down.
You know, I think one of the things we have to be concerned about too is our young leaders, how they're now looking at the Constitution and most importantly, these amendments. With the institution that you are at, how are young people looking at this? And how, I mean, you know, their perspective, of course, is very, very different than a lot of us. How are they viewing the Constitution and how it should be interpreted?
I'm at Mississippi College School of Law, and it's it's part of a Baptist institution with MC, and I think we're compared to other law schools in the country, we're a pretty conservative law school, and I get along great with my second-year students in constitutional law. I have 111 of them this year. The first-year students, I haven't met them yet. I think first-year students just need to be studying, but they've been off and they just started a Turning Point USA chapter, and I think we're the first law school to do that.
Started a what?
Turning Point USA, the Charlie Kirk organization. Yeah. And my issue with Turning Point USA, I'm all about any sort of spectrum of viewpoints being represented if the students want to have those. But what gets me about Turning Point USA is one of their main platforms, and this is Charlie Kirk's organization, one of their main platforms is called Professor Watch List. So we're basically introducing into our school this thing that says, what we want you to do is snitch on your professors. And we're going to list them on a big website where they'll get thousands of calls to harass them if they don't share our views.
Yeah. When you talk about the importance of the First Amendment as far as freedom of speech, religion, associations, so forth, which would you say is more important, the First Amendment that gives those rights or the 14th Amendment for the due process if there is some challenge to those rights?
Right. By the way, Michael, for those who don't know you, can you tell everybody who you are?
I'm Michael.
Come on, Michael.
But I would like to have the opportunity to pass out my card, which talks about civics education, professional development for teachers in Mississippi, which Willie Jones and I did one of the first professional development sessions. We had 14 teachers at Akata to start on civics education, and they were just so happy because they said we just don't have any support for teaching civics in our schools, and so we want to be able to get beyond that 14 teachers. There's probably about 300 to 500 social studies teachers in the state, and we need to be able to touch all of them because they're not getting the support they need.
And I'll answer the question that Dr. Rosenblatt answered about Michael. Michael founded I Care Citizenship, which is an amazing foundation and organization that is championing civic education not only with our young people and our teachers, but also for our communities. And of course, he's this prolific business person too. But I think when we think about the challenges that we have right now as a community, as families, as parents and grandparents, making sure that we continue to be the America that we all know that we can be, is civic education and understanding what our Constitution is, what those Bill of Rights are, understanding even our duties and responsibilities to that. I think civic education now is one great tool that we all can use, no matter what side that you're on. These are the laws that govern us. And so it doesn't matter where you stand, it's that for us to understand what those are, what those meanings are, and to be able to have great dialogue like we're having today about them is so very, very important. I think it's one of the key solutions to making sure that we stay equal, we keep this democracy that I think we all think is great.
I think we're getting back to one of your arguments or one part of your presentation here, and that's the law not taking a stand for or against any religion. And on the other hand, we have the view that that view is anti-religious.
Right.
If you're not for us, you're against us. That's what I'm hearing
Yeah, and you know,
in many quarters.
we can say that my view is this: like the free exercise clause is predominant and growing. The establishment clause that says government needs to stay out of religion, it keeps getting weakened by the Supreme Court. For example, we hear about cases like every Louisiana public school needs to put the 10 Commandments in its door. They say the purpose of this is religious indoctrination. But normally, that would be a problem. But now, well, we're just going to allow more than that. This is, people are allowed to have something that's aligned with majority values.
In the intro, if you do a lot of work with the military or security type things, and I'm not sure if this is even appropriate, but I know when, the Uniform Code of Military Justice, I was just wondering, has that changed? Is that going through a change? Because when you just mentioned the civics education, all soldiers in basic are schooled in that, the civics and the Constitution and the rights and all that. And I just wonder if that's under attack or.
Well, and this is the criminal statute that applies to military members, passed in 1951, the Uniform Code of Military Justice. And that in itself hasn't really changed. In my view, it got better in the last 10 years when we made it harder for commanders to protect sexual assault offenders. And so there's no more impunity for that. But that's not really an issue, because what they're doing when they crack down on soldiers for social media, it's like they still don't have a winning case if they wanted to prosecute them. But they can make their lives hard. They can remove them from their positions. That's sort of like pulling out the starting pitcher from the baseball team. It's like you're still on the team, but you got pulled out of doing what you had been doing before. Yeah, not getting promoted. Right.
Related to that, we have a number of high-ranking officers who have resigned, and a couple of them referencing policy disagreements. As it relates to that, their oath of office pledge to the Constitution, it seems like quitting is not adhering to their pledge to defend. I haven't been in the military, so I don't know, but from your perspective, is there a reasonable way for military folks to resist prior to a point of confrontation of what they consider to be a illegal order, rather than resigning and just saying, well, I give up? How realistic is that, given the military situation?
Y'all tell me what you think, but I've wrestled with this, and I don't think there's an easy answer. This came up in like the trials of Hitler's generals in the Nuremberg Tribunal. I just wrote a book chapter on this. It's like, what do they do? Do you want good people in those positions to say, maybe I can have an influence and prevent things? I was thinking about that, looking at that audience of generals when they were giving their patent aggrandizing speeches. And sometimes you've got to say, like, this is my line. I've got my resignation letter written, and I'm ready to leave it all. So when are you better off leaving and are there times when good conscientious people need to stay?
Normally, you would have reported something to the Inspector General's office, but that was one of the first things in
Yeah.
office. They got rid of the majority of the people you would have turned reported something to, so.
We have a question from our online audience that says, why does a president take an oath to preserve, protect, and defend that Constitution and need to then be immune to its dictates?
Well, this is our question about like saving the Supreme Court from themselves. Trump versus the United States, 2024 opinion that said President Trump enjoyed complete immunity for anything that he determined to be his official acts within his presidential sphere of acting. Had I spoken to the court, I would have said this is against international law. For example, the Genocide Convention that we're a part of says that it doesn't matter if you're a public official. If you're involved in inciting genocide, then you're guilty. Crime against torture is the same thing. So the president's, I don't think the president right now feels really any sort of oversight or accountability. I mean, what's Congress? They're staying out of session indefinitely. They're like intentionally weakening the power of the legislative branch.
Actually, I think all the branches, except for the administration, has not done their due diligence in the separation of powers. It appears to me that the Supreme Court was stacked on purpose with people that were, I won't say vetted, that saw the same, that looked the same way. And it is kind of aggravating to know that the powers that we thought were supposed to be legislative are now administrative, and nobody is saying it. So that was one of the reasons I said that, if we got elected officials from here going to DC, they just need to be accountable to what they got elected to do, and not just represent a point of view that is not in consideration of the people that they represent.
The majority of them are now getting elected by taking money from out of state, from the same building there, across the state line.
I'm sorry, I didn't hear.
Majority of them are now being elected in Mississippi based off of PAC money coming from out of state. For example, Roger Wickers, all those ads he put out there for his election that had the Air National Guard base in them, that was a Hatch Act violation. And those ads were paid for by Michael Bloomberg. All you have to do is follow the money. At the end of every commercial, when they say paid for by such and such PAC, look up the PAC, see who owns it. Out-of-state money. Out-of-state billionaires bought up all of his stuff.
Well, nothing's gonna happen.
So he's gonna be more beholden to them than to us.
The second half of your topic talked about civic engagement, and I think that's kind of where this conversation is going right now. There's a lot of attention given to the current president of the United States, but this is a situation that's evolved over time, regardless of the political party of the president in terms of all of that tension between the powers. So it's not going to be resolved short term, but there are some short term things that we need to do. So if you were in charge of the effort to realign the trajectory of the United States, what would be some of the short term things that you would recommend folks to consider, as well as maybe some longer term things?
Politics starts local. Look at the success that Margaret and the rest of you had, but just assembling together today about how to get the word out, about the common projects, about the local issues that are at stake. I mean, we're not going to change anything in Washington, D.C. from this room, but like we can make a better community where people can have their voices heard, and where the issues of out of state and non-local interests are exposed.
That's the good thing about the rallies. It does form a community where you know people and you trust other people.
Right.
And looking at trailer for the librarian. What has happened is a lot of the local school districts, because they vote for the people that sit on the board, some of them do, they're putting very religiously, I guess, conservative people that think the way that they want to think to help ban some of the books. And that started years ago when they decided that, they would do that, Now, I've always considered myself a little conservative, but some of the conservatism goes way over that way, and I'm not really all that liberal either. I spent 32 years in the Army, so I can't be, I'm kind of, and I was always in the military. We were, of course, we knew that there was the civilian chief was the president, is, executive branch. But, somebody asked about orders, following orders. We were always told that unless an order is unlawful, that, you have to follow that order unless it's unlawful. But who determines unlawful? You can just change the definition of something. You can change the law. That's what's happened sometimes.
The standard that started in Nuremberg and then continued out in Eli is that soldiers have to disobey manifestly unlawful orders. That means that it's obvious to everyone, basically, with common sense, that it's illegal. There's a whole lot of things that aren't manifest that people have questions about. So that's what we're trying to do with that National Institute is keep soldiers informed and give them an independent voice when they're put on pressure situations like you have to go to Chicago right now.
When you're talking about the First Amendment, I'll give you that we're talking about civics being important to get back into the classrooms. But I'm also hearing from our president and our governor that we need patriotic education in our classrooms. I don't know what they mean by that, but I have a sense that that's not what I think civics is. And the same now with the Pentagon having a different press corps. We're going to have a press corps, but we're not going to get legitimate information out of the press corps that the Pentagon now has installed. How do you combat that? The public thinks we have it, but we don't really have it.
Patriotic education. Does that mean you can't say anything bad about American history?
Exactly.
That slavery was just fine.
We have to change our museums, we have to change our books, how do you fight that?
Get out the vote.
Okay, if you're so gerrymandered that your vote doesn't really have an impact, how do you get around that? I feel like we're boxed into a corner here.
So how do you fight that?
Several years ago, I tried to base one of my voting decisions on voting not for anyone who had fight in their campaign. And I ended up not having anyone to vote for. I'm not a scholar, but I've been studying the Constitution for the last 10 years or so. And it was only until about the last 2 years that I realized the most important page on the Constitution was the last page, where 13 out of 13 colonies signed on to it, even though they all weren't happy with it. And some of them didn't like each other, but apparently they trusted each other because they agreed to come back for the Bill of Rights, and they actually did it. That's one of the most impressive things. But what I came to conclude is that as important as all of these sections and articles are of the Constitution, what was most important was that the people agreed to come out with something that we can all live with. Because there's people we don't know, don't like, don't want to get to know, don't want to associate with, and I got my right to be left alone. But we need to live together. And so, it's very much of a struggle because there are a lot of folks who you can't have a factual, honest conversation with them because we're too mired in our own opinions and whatever our assumptions are. But somehow we got to figure out a way that we're going to work together to make things work for everybody. And it's not a short-term thing, but I think, again, local politics, but really League of Women Voters, that's why I'm here. I don't normally like getting out of the house this early on Saturday. But, League of Women Voters, we're really looking to partner with the League of Women Voters, because I think in terms of political impact and political impartiality, I can't think of any organization that has a better reputation than League of Women Voters. So if you can get it right, there's something that you can represent to a lot of other folks who are just lost. They're just following the word of the day, and it don't make any kind of sense. So, I think, starting from local and then just really doing what you already are commissioned to do, just figuring out how do we do it at a better level, how do we do it at a better connected level, and how do we work with more people, given that, we only got 24 hours a day, and how do we change things and not just hope somebody does something.
How can we negotiate? How can we learn to negotiate to achieve a compromise that we can live with, we can all live with? That's what you're, to me, that's where you're coming from.
Sabina, you had a meeting, you co-hosted a meeting in this very room, was it June or July? And it was pulling some organizations together based on the COFO model. You want to talk a little bit about that?
Well, I can start at the
Because they came together, there was different
I know.
groups.
They're willing. I'm just not able to continue that fight.
Yeah.
But yes, we did pull together, gee, I don't know, there must have been 10 or more organizations that were interested in the call that I put out, and we met twice, once over at Jackson State and once here. Then I went away for the summer, and I'll tell you the truth, what stopped me, and I probably should be ashamed to acknowledge this, but this is the truth. There were some strong voices that spoke that such organizations should be partisan. And I felt very strongly, and some of the others involved felt very strongly, that it had to stay nonpartisan.
It had to be.
And that was the COFO model. And I gave up the idea, but the idea is still good, and somebody should pursue
It's
it.
still good,
Yes.
it's nonpartisan, but
Yes.
we cannot sign on and be a partner or collaborator with any organization that is not nonpartisan. That is in our bylaws, and that, that's our brand that we have to stick to. And I think it's a great one. But to get back to what Mike was talking about, Mike, right? If we can get organizations together that are nonpartisan, that would be great. But and I know that a lot of organizations have different points of view about different things, but what you do when you come together, you have to come together on the things that you agree on to focus on.
And that's kind of why the COFO model is a good model to start with and to build on in today's world.
Does everyone know what that means?
And what worked under that COFO model, Serena? Because I think our audience is listening online too, who may not be familiar with that COFO model. Can you tell us about that?
Well, I think it was coming to a compromise. There were a lot of values, a lot of issues at stake, and I think the members of the COFO, and I'm no expert in it, that's for darn sure. I think the members decided to keep their eye on the prize, if you will, and to do it in a way that respected the values, the primary values of all the organizations involved. And so that took a lot of dialogue and a lot of guided dialogue, facilitated dialogue. And that's sort of where we were moving to, and then it lost steam, but it's still a good idea.
Is it Congress of Federated Organizations?
council of
Council.
Council of Federated Organizations.
Yes.
And they actually have an office on Lynch Street, and it was like SNCC and, was the NAACP, I'm trying to remember.
I don't remember who all was a part of it. The
There
student
were several organizations,
coordinating
and
committee.
they did have some differences in what it was that they, believed in. Let me see if I can find an organization.
And it's still, there, the building, right?
COFO still exists.
Yeah.
Yeah, I have a question for you. You mentioned that there was a lot of times in discussing the values of the various people representing those organizations. Is your sense that the breakdown of the collaboration came from disagreement over the values, or when it got down to particular issues and actions? Where do you feel or was it the fact that you just took a break over the summer and the energy fizzled?
My energy fizzled, one, because I had a health situation. The rest of it, the excuse I gave was that the voices in favor of partisan action were too strong, that I didn't feel like I could overcome that strain.
So the
But it could happen, and there's stronger people than me right here in this room that could pick up that
The
fight.
conversation that got to the point of specific issues and actions. And
Yes,
that's
sir.
what okay,
Yes.
thank you.
But to your question about what can we do, where we are in Madison, Mississippi, the league has an initiative called Unite and Rise, and it's about activating 3.5%.
You mean,
Or is it?
it's 8.5.
8.5.
5 million.
Which is 3.5% of the U.S. population, to take some action in resistance to the things that are wrong, that we, agree are wrong. So,
There's a tipping point.
yeah, tipping point, and Swarthmore College had a institute that studied peaceful revolutions, such as Egypt. And it took a while, it wasn't overnight, but there were several instances where they overcame a dictator in charge by these kinds of actions. So it's something we look at and are trying to promote as an organization.
Is that 3.5% of the American population, is she saying? Okay.
And so are they explicitly asking folks to resist something, or is there
There's a playbook.
an outcome that they're looking to accomplish?
Yeah, they sent a playbook out quarterly, and there was some confusion at first whether or not we could participate in No Kings. And we can, but it has to be in a nonpartisan way. And if you wear anything that says Legal Women Voters, you cannot have signs you can have signs for causes, but with the league, you have signs on many lawsuits too. And that was one reason why I guess anyway, we signed on to some lawsuits and we found some lawsuits, but we can actively participate in those kind of things, but we cannot go against any political party by putting it that, or any person that's running for office. We can't go against them or for them. It has to be a cause that we have on our sign if we have a sign.
You're hearing our discussion about nonpartisan, how difficult it is when the threats to democracy tend to be coming from the current administration, which is Republican, yet we try to remain nonpartisan. So it's really a fine line that we keep trying to toe. And we do file lawsuits.
Yeah, well, adhering to the Constitution is nonpartisan. And policy outreaches of that.
Right.
Well, it used to be nonpartisan,
Yeah.
adhering to the Constitution. Just like adhering to freedom of religion, no religion used to be the view, and that's no longer the view, at least not in this day and age. So,
but I would want to push back against this particular crisis being all one-sided in terms of political parties. Because if there's anything that has been all partisan, it's been politicians trying to get what they can get from whatever their positions are if they don't have the right attitude about it. And as we, Congress, they didn't just flip over and decide to hand over the government. They've been doing it. It's been that way for a long time. Now the crisis, what our current president is doing is causing crisis because of the quantity of what he's doing, but qualitatively, other presidents seek to usurp power, and Congress has abdicated their responsibility. So we're not clear in terms of what the problem is if we focus on opposing the symptoms. We're never going to cure the disease. So I'm just like, I always have to be careful when we start saying, it's like I have some black friends say, well, white people are this, or white people are black. And it's not. Every individual comes down to what it is. And so if we can, shape our conversations in terms of, as you say, those common values we have, because the Constitution, this grant we got to do teacher development, they said it was a grant to teach underserved students their rights. We need to have a program that Jackson Academy and the very privileged kids will understand this Constitution, that protecting the Constitution for everybody. And it's not a class thing, but we're not careful. We just buy into the dividing ourselves up instead of figuring out how we're going to work this together. So I just want to push back against it being a Republican thing, because it's evolved from the habits of both parties.
Which ties back, all the way back to when they started allowing people to get away with PAC money, unlimited amounts of PAC money. Because back when they only allowed X small dollars from individuals to go to campaigns so that they couldn't be bought out by billionaires. Once they started allowing the unlimited PAC money, which has been happening long before, for over 20 years, they've been eroding their way into, they haven't passed authorization and appropriation bills on time for over 25 years. So both parties have been in power during all that time, and both parties have been slowly being bought up and controlled by the billionaires. So if you don't stop the unlimited PAC money,
and the rationale for the PAC money is free speech.
Yeah.
These corporations have speech rights, and they exercise their speech through dollars.
which is what allowed them to buy up all the politicians and the judges, because,
Which came from the Supreme Court.
Yes.
but it's basically
That school, high schools in the area, do you help very much like project law?
Yeah.
Do you have any? Because I know you got
So-
your.
I have not, but I could. Some civic groups, but not high schools.
What was the question, Margaret?
I didn't hear what the question was.
Sorry.
I asked if he has or has been invited to or gone to high schools to speak about the First Amendment, and speak about something like we just witnessed. You mentioned the schools in the communities, like the so-called privileged schools or whatever, but putting it out there that kind of like what we just witnessed.
Well, if you hear about anyone who wants someone to go out, then I'd be glad to.
I can check into that.
Schools seem to be very protected, even when we want to go in to register seniors to vote. There are many schools that will not let us go in and do that. Rankin County, well, now, we're going out for advocacy day, but in the past, trying to get in Rankin County is like trying to get into Fort Knox almost. To do, voter registration and voter education. And we are nonpartisan, but,
You have to have a white man there.
But it needs to be done, we need to figure out, but it is hard, it's hard dealing with schools.
yeah.
And it should be.
And I think that's what the We the People grant that we're working on. The teachers get an opportunity to not to form perceptions or information to the students. They teach the Constitution as it is, and then they give the opportunity for the students to be able to relay that in. They do mock hearings, and they help the young people go through that process so that they can have their own perspectives, and you can also, most importantly, share that information with their parents to begin a dialogue at the kitchen table. So parents can feel like, I have power and control over how this information is being interpreted and sharing with my children. So I think young people, we adults are in these spaces like this, but it's so important for our young people to be able to have their own conversations, because they're having it. They're having it on the playgrounds, they're having it, at the stadiums where they go and all of this stuff. But we as adults need to make sure that we kind of step in and also be able to help them guide. It's so complicated for us, because you can imagine what it is to our young people.
And as Willis said, the teacher development program that we're doing, we're also looking for people from the community who have an orientation. You don't need to be a subject matter expert. It's just a matter of facilitating the process. And we've got a format for that. But basically, we are looking for folks who are willing to go into the schools and work with the teachers, and just to have that conversation with students. Again, not to be the expert provider of data of information, but to help the conversation flow so that they can discover for themselves what's involved in running the government, because that's really what the Constitution is all about. And originally, what most of education was about was running the government.
Okay.
One last thing. We mentioned.
Oh, to me? Okay.
We mentioned the Unite and Rise. League members know how to access that. Can't everyone just go to LWVUS and look at it?
Yes.
Yeah, so that's what everybody needs to know in case you want to know more about Unite and Rise. But look under LWVUS, Legal Voters US.
As a matter of fact, we can send it out to all of the members. Instead of you going and look, because sometimes people go to websites and they get a little turned around about what you're looking at. So we can send that out. We can package that and send it out.
And that's lwvus.org for our online audience?
No, it's just lwv.org.
Okay.
So talking about the screenings, I went to the Librarians screening page where they talk about the movie, the documentary. They're all over now. So they've expanded to North Carolina, they've expanded to Alabama, Birmingham. So I think it's a very good chance we'll get it here, especially if we all email them and they have a location for the screening of the Librarians. They're also in Georgia. They're also in Ireland, if any of you are headed to Ireland. So anyway, Margaret, Willie, and I can work on this and see if we can get a screening here in Jackson. I think it'd be neat.
And what we'll do through iCare Citizenship and the teachers we're working with, we can take, I'm assuming that the preview is pretty much easily accessible.
Oh, yeah.
Because the teachers we work with have said, anything you can give us that's 3 to 5 minutes long works best for our class so we can engage it. Because otherwise, you've got to move it and everybody goes.
Yeah, it's on YouTube.
Okay, so so that we can start doing now. Okay.
Anyone else?
I love it that the Constitution's not partisan.
We've discussed a lot, and I do appreciate it. That's why we definitely appreciate you coming in and giving us even more to think about. Because like I said, it's very important for us to educate ourselves and not focus on one news outlet. And sometimes I don't focus on any of them because it's a bit much for me sometimes. But that's just me. Thank you for coming and participating, and thank you. I really thank Megan for coming up with it. Megan has some great ideas for speakers. She was the one that had the idea to get the mayors together too, and that went over very well.
That was a marvelous idea. Our League of Women Voters, so Frank and Mike, if you'd like to join the League of Women Rose, we'd love to have you.
Both of them. And we do have several men, that have joined. But Lee, we will be sending as much information as we can out to you, and if it's too much, just don't read it or delete it. But as many opportunities that we have. So unless there are any closing points or